Aloha, this is Professor Porter. We're talking about hearsay and specifically hearsay exceptions, the reliability exceptions under 803. And there's one thing that that students often and people new to evidence often confuse that I want to make sure to take up in a separate video. We have separate videos that will talk about some of the 803 exceptions. But as it relates to 803.3, and I do have a separate video on 803.3 state of mind, just think state of mind often gets confused with something else that I put in terms of state of mind, and that is a not hearsay argument, an argument for the proponent that he says or she says that a statement is not offered for the truth of the matter asserted, but instead offered for circumstantial evidence of state of mind. So one is a definitional, not hearsay, not for the truth of the matter asserted argument. The other one is a hearsay exception under 803.3. Let me talk about both of those and separate them for you. So again, the quick refresher, 803.3, if you remember. This has to do with the then existing, what's going on with you. I'm hopeful, I'm sad, I'm dizzy. It's a direct expression of my then existing state of mind. This is the declarant telling us straight up, no inference, no leap, no connection. This is what's going on with them, right? And remember that it includes this sort of not only what's going on with them in their mental, physical, emotional state, but it's also their present intent to do a future act. I'm going to get a bank loan tomorrow, right? It's what's going on with them mentally, physically, emotionally, or my present intent to do a future act. That's 803. But just think about it. This is the declarant just saying it to you. This is the declarant with no work on the listener's part, nothing to unpack, saying, this is what I got going on. I'm hungry right now. I'm super tired and headachy, right? They're telling you what's going on with their physical condition. They're telling you about their present intent to do a future act. There's nothing to decipher. And if you recall, remember, the first thing the proponent can do as soon as the opponent raises a hearsay objection, they say objection, hearsay in open court, and we make our way to sidebar. Essentially what the opponent has done is they've taken their hearsay flag, they've thrown it in the middle of the ring, they say, stop what you're doing, stop asking questions, Mr. Proponent, of your witness that you're about to get into this out of court statement. I'm throwing the hearsay flag, objection, hearsay. They make their way over to sidebar. The opponent owns that definition, out of court statement, truth of the matter asserted, and they're able to expand upon it and talk about why this violates the rules, why this violates the policy of the rules, that we want firsthand accounts, that we want our opponents to be able to cross-examine firsthand declarants. We want a jury to evaluate the people that say words. With hearsay, they don't get to do that because we have a second-hand account. We have one person dragging in the quote bubble that belongs to someone else. The proponent at the same sidebar, the first thing that they can do before they get to exceptions and before they get to reliability exceptions under 803, like 803.3 state of mind, is they make an argument against the definition, against 801C. And I talk about this all the time as the opponent says, objection, hearsay, yes, sir. And the proponent says, nah, you don't have that definition. You don't have the 1, 2, 3. And if you're guessing at home, out of court statement, truth of the matter asserted, the fight is with the last element. The fight is with why is the proponent offering this? They're offering this to prove the truth of what's in quotes, the truth of the matter asserted. So if I'm the proponent and I'm making a definitional argument, one of the things I can do is I can say, Your Honor, this is not hearsay. It's not offered for the truth of the matter asserted. Instead, it's offered for some other purpose. One of the other purposes that we talked about kind of a top 5 or Porter's top 5, is state of mind. So state of mind, that not hearsay argument, that not truth of the matter asserted argument, sounds a lot like that 803.3 state of mind exception. What we really mean by state of mind here is I have circumstantial evidence of the declarant state of mind. So if the declarant says something, or they are talking in gibberish and they're saying weird things and they're screaming on the side of the street, and that's the declarant, I might be able to look at it and say, based on all that they're saying, I can infer that something's going on with them and they're not right today, or maybe they're off in some way. I'm making circumstantial leaps. I'm evaluating the content of the statement and making a leap that something's not right with them. Same way as if someone said, oh my God, I am so hungry I could eat a horse. Well, the content of that statement is I'm so hungry I can eat a horse. What I'm going to derive from it is this person's starving. This person hasn't eaten. I can gather something about what's going on with them. Every bone in my body hurts. I feel like I could die. I take that statement and I can infer this is a declarant telling me they're in extreme pain. So I'm doing something with the content and getting to a state of mind for the declarant. Notice the difference. So the difference is when I'm making this circumstantial inference under a not hearsay definitional argument under 801C, I nearly died when I heard the robber. What I'm really doing there is I'm looking at the content of that statement. And when they object to hearsay, I'm trying to put in that statement as the proponent. I ask my witness, I said, what did the person say? And this in the red is their statement. What did the person say to you? Objection, hearsay. The opponent's right. We're going over to sidebar. They're embracing this as out of court statement offered for truth of the matter asserted. My response is, as the proponent, I make a definitional argument. I say, Your Honor, this is not hearsay because I, the proponent, am asking this question of this witness, am not offering it for the truth of the matter asserted. I'm not trying to prove I nearly died when I heard a robber. Instead, what I'm trying to prove is circumstantial evidence of the declarant's state of mind. I'm trying to prove that the declarant was terrified at the time. I'm trying to prove that they were really scared, not that they nearly died. I don't want it for that truth. And just notice that circumstantial evidence that I'm offering it for this purpose, not the bad purpose of the truth, that could provoke a 105 limiting instruction. The court, if they allow this testimony in for the purpose that the proponent wants, ladies and gentlemen of the jury, you are to consider the statement only as it relates to circumstantial evidence of what was going on with the declarant, what they were feeling at the time, not for the truth of this statement. No one can argue the truth of this statement after. Notice the difference between an 8033 state of mind exception type statement, the narrow circumstances of that exception. This would just be the declarant saying, I'm terrified. And what we would say, what the proponent would say here is they would say it might be hearsay, but an exception applies. This is a state of mind exception under 8033. This is a then existing statement of someone's physical condition, their mental condition, their sensation that's going on. The same way as if they said, I'm going to get a bank loan tomorrow, or I'm dizzy, or I'm scared, or anything. You know, they can say anything that's a then existing statement of what's going on with them. So just think, if it's something where we're trying to make an inferential leap, we're using it as circumstantial evidence to say what's going on with the declarant, that's probably going to be a not hearsay definitional argument where you say, as the proponent, this is not hearsay, it's not offered for the truth of the matter asserted. Instead, it's offered for the circumstantial evidence of the declarant's state of mind, specifically that that person was terrified because they said they nearly died. When it's the other circumstance, the declarant is just telling you, no leap needed, no circumstantial evidence needed. They're saying out loud they're then existing. If they said 2 days ago when I heard a noise down in the basement, I was terrified, it's not going to qualify as an 8033 exception for state of mind. It's then existing. I'm terrified. And the same thing is if they include a because statement, if they say, I'm terrified because I heard something down in the basement, I'm terrified is going to be allowed to be in. The because and the reasoning behind it is not. So pay close attention to separating out circumstantial evidence of the declarant state of mind and Federal Rule of Evidence 8033, the state of mind exception.